Case in Point with Suzanne Sherman.
I'm fixing to commensurate this trial here. We gonna see if we can come up with a verdict up in here.
Well, hello and welcome to Case in Point. I'm Suzanne Sherman, and you've tuned in to the Cerberus Radio Network, where we defend liberty and freedom from the flames of tyranny. Jeff Johnson is here in our cyber studio. He's producing the show. I want to thank him for all the work he does behind the scenes. Thank you very much, Jeff, and for all the efforts that you do here to keep us going. I want to remind people you can follow us on Facebook. We have a page, CRN fan page. We're also at facebook.com/Cerberus Radio Network. We have a Twitter page with the same name, as well as YouTube for now, and a SoundCloud page, Cerberus Radio Network, where all of our shows are listed. They're archived and they are available for free download. We have Liberty Minutes with Greg Carpenter, the Mark and Suzanne Show, Revolutionizing Radio, my other show, the Wasatch Report. Here we are, Case in Point, a relatively new show. This is going to be actually episode 3. Joining me is my very good friend and, believe it or not, amateur historian, Dave Benner, an accomplished author. And we're going to be discussing the Incorporation Doctrine, and the case that I'm going to discuss, where we're going to apply and explain this, is City of Chicago versus McDonald, or McDonald versus City of Chicago. And this was a case involving firearms, and I'm going to back up a little bit and give some history also with regards to the District of Columbia versus Heller. So we're going to talk about the meaning of the Second Amendment and also how the Second Amendment was erroneously applied to state law in the McDonald case. I want to get to an article that was published by the 10th Amendment Center, and it is called "The McDonald Case Was an Originalism Failure." As I explained in the article, perhaps the most significant and long-lasting legacy of a Donald Trump presidency would be his appointments to the United States Supreme Court. Supporters of candidate Trump expressed excitement over this opportunity to appoint a jurist who'll be an originalist along the lines of the late Justice Antonin Scalia. He's been touted as a textualist when it comes to interpreting the Constitution. This means that he would look to the plain words of the document when interpreting what it means. However, as I pointed out in an article called "How Heller Botched the Second Amendment," his opinion in the District of Columbia versus Heller, he shows how textualism can actually result in an improper interpretation of the Constitution. I'm going to back up and talk about Heller just for a moment for some background reference. So in Heller, Scalia properly held that the District of Columbia's restrictive firearms laws were unconstitutional. However, his textual analysis went astray when he decided to explain exactly what the Second Amendment meant. In so doing, he actually ignored the text of the amendment and concluded that its protections, in my article I have that in quotes, by implications were listed to handguns. He reasoned that because of their popularity and ease of use for self-defense, that they should be protected. And he explained his explanation of what shall not be infringed resulted in the phrase only protecting a limited category of firearms, leaving the door open for others to be infringed upon. And as I explained that in an article, we're seeing now many bans on the AR-15s already in effect and proposed even from Congress. Donald Trump actually said that he would consider it the other day when he was meeting with Dianne Feinstein. So 2 years after the Heller opinion, in 2010, firearms laws once again found their way to the United States Supreme Court in the case of today's topic, McDonald versus the City of Chicago. This time, the city laws were the source of a controversy as opposed to the federal government or the District of Columbia acting under federal authority. So at issue in McDonald were laws passed by the City of Chicago and a suburb of that area called Oak Park. These ordinances effectively banned handgun possession by private citizens, and petitioners sued in federal court for state law, seeking declaration that the ban, along with related ordinances, rendered them vulnerable to criminals. They asserted that the ban and related city ordinances were in violation of the Second and 14th Amendments. The district court upheld the constitutionality, I beg your pardon, of the ban, and they noted that Heller had refrained from issuing any opinion as to whether the prohibitions in the Second Amendment applied to the states, and asserting that the court had the duty to follow precedent. In that regard, they were correct. For the Supreme Court to hold these laws unconstitutional, the justices had to find a way to incorporate the Second Amendment to the states, and this would essentially grant a federal veto over state laws, a proposition that was rejected outright during the Philadelphia Convention. Carl Jones, a good mutual friend of both Dave Benner and I, and Jeff actually, discussed how a proposed bill that was popular among firearms enthusiasts was in direct contravention to the Constitution as ratified. And in that article, it's also published by the 10th Amendment. It is called National Reciprocity is a Trojan Horse. And it's relevant to our case here because we explained that in order to understand the meaning of the Second Amendment, we have to consider the context in which it was adopted. One must also grasp the broader intent of the Constitution, which simply instituted a union of sovereign republics and created a general government to which the specific enumerated powers were delegated. That being said, I want to bring Dave Benner into the conversation because, Dave, you've written a book called Compact of the Republic, which is based and explains that very premise. I'm going to introduce you. Welcome to the show, and I'm going to look at that concept.
Yeah, thanks, Suzanne, for having me. I really appreciate it, and I totally agree with your analysis on the Heller case. And appreciate you introducing Compact of the Republic. I argue in that book that the states simply predated the federal government, and it was the autonomy of the states, which had, independent legislatures, courts, even state religions, that really constructed the Union and breathed life in the Constitution based on a compact, which is a multi-party arrangement among sovereign powers. So that book goes into the entire genealogy of how that transpired, and then how that mentality and that organization of the Union has eroded through time. So thank you.
You're welcome. I think what people really have a hard time grasping is when the Constitution was ratified, that we became one nation, indivisible. They have accepted that. They've become indoctrinated when that really didn't happen until after the war against Southern secession. That being said, again, Compact of the Republic in simplified terms means that 13 sovereign and independent states on a par with England, France, and Spain came together and formed a government for very limited purposes. So that applies to the Second Amendment here in our case, because it was intended to eliminate the need for standing armies by keeping a militia, meaning every able-bodied person under the auspices of the individual states. Again, that is explained brilliantly and eloquently in Dave's book. The founding generation feared standing armies as they led to war and the centralization of power in government. James Madison had even said that the war is a parent of armies, and from these proceeded debt and taxes, and that armies and debt and taxes are the known instruments for bringing the many under the domination of the few. That was prophetic because that's exactly what we've seen. It's these prognostications have come to fruition. I want to bring up also St. George Tucker. He wrote the very first comprehensive legal commentary on the Constitution. He was very clear when he stated that the Congress of the United States possesses no power to regulate or interfere with the domestic concerns or police of any state. It belongs to them to establish any rules respecting the rights of property, nor will the Constitution permit the prohibition of arms to the people. So, Dave, this really goes along with what you say in this book. Why would 13 sovereign and independent nations delegate such a power to the general government, given their fear of standing armies?
Yeah, absolutely. I think that you described that pretty well, because one of the things that we find as scholars of the founding period is that one of the most universally held maxims amongst basically all political factions was a complete apprehension of standing armies. And this applied to people that supported the Constitution, that opposed it. Make no mistake, these people argued about a lot of things, but one of the things that they didn't particularly argue with was the threat of a standing army. And the reason why was because they were students of history. They looked back and they saw what Pride's Purge did in England, and they saw what Julius Caesar's usurpations did to end, the Roman Republic. So this time-honored tradition was one of the most paramount factors of the American Republic.
And we know they knew from experience that a standing army could be used to crush dissent and further oppress the people seeking liberty. So the legislative powers, now that we have this new Republican system of government operating under a federal system, the powers of Congress were set forth in Article 1, and they were enumerated specifically under Section 8. Article 1, Section 8. Other than the power to arm the militia, no mention of regulating firearms is listed. Accordingly, now the 10th Amendment comes into operation. The power is not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectfully or to the people. Now, Dave, can you tell me anywhere under Article 1, Section 8, can we find a delegated power to regulate firearms?
None at all. And actually, you bring up a good point, because even if there is some way that the Second Amendment would be repealed, the federal government still wouldn't have power to do that, because the advocates of the Constitution in basically every state argued that this was a constitution of enumerated powers. It's a federal constitution. It's not a national constitution. So the federal government doesn't have that power regardless.
Exactly. So what we have here now, this means the states, never having delegated such power to the general government, reserve for themselves the exclusive power to regulate firearms. The Bill of Rights was never intended to apply to the states. We're going to get into that in a little bit, and then Dave's going to really explain the intent of the 14th Amendment, because that was the springboard upon which they have applied the Bill of Rights to the states, and I argue have been used to systematically dismantle our federal republic. So again, there was no intent to apply the Bill of Rights to the states, but this is exactly what the issue was in McDonald. And the court applied the Bill of Rights, the Second Amendment in particular, against this state. In his concurring opinion, Antonin Scalia also shows that not only does his textualist approach fail, see Heller, again, we discussed that early in the show, but now also he has shown that his originalist approach also fails. His analysis as to what rights are covered in the Second Amendment is problematic. And again, as I explained in Heller, he acknowledges that the right to keep and bear arms is a right predating the Constitution. The historical context of the Bill of Rights is clear, and Dave's going to expound upon that momentarily. They do not confer rights upon individuals. They are restrictive in nature, and the restrictions fall upon the general government. We can tell by the preamble to the Constitution, and we can also tell by the first words of the First Amendment: Congress shall make no law. It doesn't say Congress and the states. So the first 8 amendments merely reiterate that these were areas considered to be hands-off to the general government. Regulation of firearms was one policy over which the states retained authority. So applying the Bill of Rights to the states was properly understood as undermining state sovereignty. Enter the 14th Amendment and what that was intended to do in that regard. Dave, you have another book that is an absolute gem. In fact, I have to call this a booklet, the 14th Amendment and the Incorporation Doctrine. It's about 50 pages. I think actually 41 pages is about the author. So in 40 pages, you managed to explain what so many people, including Supreme Court justices, just seem to miss. Tell us about your book, and let's apply that to case in point, McDonald.
Yeah, so thanks, Suzanne, for that introduction. So the 14th Amendment and the Incorporation Doctrine is a booklet that I chose to write after kind of studying this topic for some years and really kind of getting into what are considered the most primary and important texts on this. The best scholar that's covered this is Raoul Berger, and I know that you and Jeff have probably pointed him out several times, but I feel that Berger, although he's totally right in his analysis and historical investigation, it can be tough for, some people to ingest and kind of take in. So what I did was I boiled down all the best parts of Berger's arguments into this booklet and explained why the 14th Amendment was never intended to incorporate the first 8 amendments as limitations against the states, even though the federal government, the legal community, legal doctrines in general hold that as essentially a universal truth. I display and describe why that is not the case and why the 14th Amendment only had its expansive kind of interpretation in that regard about 50 years later.
Yeah, and as I explained in this article as well, the 14th Amendment served 2 distinct purposes. It negated Dred Scott versus Stanford from 1857, and it constitutionalized the Civil Rights Act, which conferred basic United States citizenship to newly freed slaves. That being said, why don't you tell us a little bit about the 14th Amendment, give us a history, and then we'll explain what became used as via the Incorporation Doctrine to effectuate a federal veto over state laws. We know that a congressional veto or negative over state laws was rejected at the Philadelphia Convention, but a judicial veto has the same practical effect. Go ahead, Dave.
Yeah, so I'll try to put this history in a nutshell of the 14th Amendment here. It's basically after the Civil War, Republicans in Congress wanted to pass legislation that prevented the states from infringing upon the most basic possible rights that we would conceive of when it came to the freedmen, the newly freed slaves. And the Civil Rights Act of 1866, as it were, articulated these things plainly. And I put that in the work. But some of these rights were the ability to inherit property, purchase property, appear in court, and things of that sort. And basically, the Civil Rights Act articulated that it was to the full and equal benefit of all laws and proceedings for the security of persons and property, as is enjoyed by white citizens. So the legislation made clear that this was to intend that the freemen shared those same basic rights. But the Civil Rights Act of 1866 was constitutionally controversial because many believed that if the Democrats got elected into Congress again and elected a new president, perhaps, political waves would be such that this act would be repealed, or that the courts would weigh in and say it's unconstitutional. So this led to the 14th Amendment. This was a methodology to codify that in a way that was much stronger than normal legislation.
That being said, also, I have yet to discover the constitutional authority for the Civil Rights Act itself of 1866. So bringing this now into the discussion of our case here in McDonald, Antonin Scalia criticizes Justice Stevens for failing to apply what he referred to as the Palco test in Stevens' dissenting opinion. This was a case emanating out of Connecticut. It was called Palco versus Connecticut in 1937. The court, in determining whether to incorporate the double jeopardy clause, which can be found in the Fifth Amendment, against the state, required only that a fair and enlightened system of justice would be impossible without that right sought being incorporated, or requires an addition in the right to be rooted in the traditions and the conscience of our people. Another statement they use is some rights, they call them fundamental rights. They are so implicit in our concept of ordered liberty to be ranked as fundamental. And then we bring in the 14th Amendment and pretty much say that the Supreme Court has a say in pretty much anything going on with the states. That's where we've gotten to at this point. The Palco test, as used in this case, conflicts with the Constitution and the 14th Amendment as they were understood when they were proposed and ratified. When he introduced the Bill of Rights to Congress, James Madison wanted some of the provisions to be made applicable against the states where he argued liberty would most likely be threatened. Again, this was rejected outright. So at some point, now we get the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Now, Dave, you explained the narrow interpretation of this amendment. In fact, tell us a little bit about Barron versus Baltimore. That was the first time that it was questioned whether or not the states would be accountable for the Bill of Rights.
Right. So in 1833, a suit against the state of Maryland alleged that the Fifth Amendment right to due process extended to inhibit the state governments. And this was really one of the first times this argument was ever made. And keep in mind that, this is over 40 years after the ratification of the Constitution. And in really one of the only instances in which I think you would agree with John Marshall, he correctly opined in his opinion that the first 8 amendments don't apply to the states. And really, you don't even find legal scholars even that disagree with us in terms of incorporation that argue otherwise. Basically, no legal scholar argues that the first 8 amendments were intended to be incorporated against the states prior to the 14th Amendment. Of course, we don't think the 14th Amendment does so, but Barron v. Baltimore was an important opinion in this regard that kind of backs the original textual and contextual justification of the Constitution.
So apparently something changed, because we had hardcore nationalist Justice John Marshall saying that he could not find the language. He said, here's his quote: "Amendments contain no expression indicating an intention to apply them to a state governments. This court cannot so apply them." Well, what changed? In 1925, the Supreme Court magically found this authority to apply the Bill of Rights against the states in a case called Gitlow versus New York. The application, as I explained in my article, of the 14th Amendment and using that to incorporate the Bill of Rights against the states is problematic, and it's also not supported by history. And since this is a historical background part, I want you to explain what was debated in the 39th Congress, because as we have already explained in other shows, and I talk about this all the time, the key to understanding the intent of the Constitution, contrary to a caller on my last week's radio show, is not being a member of the Supreme Court. It is to rely on Supreme Court decisions, but you have to look to the ratification records. That being said, Dave, why don't you talk a little bit about what was discussed and debated in the 39th Congress when they proposed this amendment?
All right. So, there was some background already given where the chief objective of the Republicans in the Congress was to constitutionalize the 1866 Civil Rights Act. And some of the chief advocates of that amendment, the 14th Amendment that we're discussing today, said that the amendment was basically synonymous with the law. For instance, West Virginia Representative George Latham said that it covers the exact same ground as the amendment. That's a verbatim quote. Senator Lyman Trumbull, also one of its chief proponents, made painstaking strides to ensure its passage on account of it being a, quote, reiteration of the rights set forth in the Civil Rights Bill. So essentially, this was doing nothing more than articulating that the freedmen had basic rights as articulated in the 1866 Civil Rights Act. And Raoul Berger makes the best case of this in his famous book, Government by Judiciary, when I cite that the proponents of the amendment never argued that this would give the federal courts a policing power into matters and laws of the states that they found personally in ill repute. And that's really what we've come to find in jurisprudence of the 20th and 21st century. It's basically not whether the law is particularly constitutional or not, it's whether judges like the law in question.
Exactly. And I remember sitting in my constitutional law class when I was attending law school, and our teacher, who was a Superior Court judge in Santa Clara County, saying that these rights now that were never there, and he put his hand up in the air in front of him, and imagine putting your fingers and thumb together and raising your arm from the elbow and opening your hand. He said, these rights spring forth from the Constitution, from the 14th Amendment. Well, that's exactly what they did, but they did not do so in conformance with the constitutional history. So what happened? By 1925, the progressive era was in full swing, and the Supreme Court was well on its way to imposing a full rewrite of the Constitution upon the states, as you explained earlier, in contravention to the intentions of the ratifying states at the time. So I talked about Hugo Black in this article, and he was appointed by Franklin Delano Roosevelt, and his first purpose was really to support the New Deal. And by doing so, he joined a new majority that eschewed the Supreme Court's traditional or intended role of checking congressional efforts to legislating beyond its enumerated powers. The institution was intended as a check, had become a legislative body in its own rights, with rulings being handed down to conform with the preferences of the sitting justices. So now I'm going to turn our attention back to McDonald. The essence of Antonin Scalia's concurring opinion was to criticize Justice Stevens for using his policy preferences, and that's what you alluded to earlier, Dave, was these judges couldn't find the constitutional authority for their opinions. They just liked, they wanted to follow along with their policy preferences. So that being said, we have now an exception that he took for Stevens' subjective application of due process. I'm talking about Antonin Scalia, to include new freedoms. Remember the ones I alluded to, I referred to springing forth from the Constitution. The framers were too narrow-minded to imagine social policies and firearms were deemed appropriate to be handled locally by the states. He chided Stevens for failing to consider the Second Amendment rights as a fundamental enough to be incorporated against the states. Scalia missed the point of the Second Amendment, that it is a restriction upon the general government. This is why I tell people there's no such thing as a constitutional or a First Amendment, Second Amendment right, because when you call them rights, we know, we've heard time and time again, rights are subject to regulation. And that's exactly what they do. They restrict them to conform with their policy preferences. So by acknowledging that this right is deeply grounded in our nation's history and tradition, was apparently sufficient to substitute the court's judgment for amending the Constitution. What we really had was a de facto constitutional amendment pursuant to Article 5, only nobody invited the states. So by claiming power over areas in which the general government was never delegated, issues over which the states clearly retained for themselves, we have an imperial court that fundamentally transformed the federal nature of our constitutional republic. They did this by completely disregarding the history of the proposal and ratification debates surrounding the 14th Amendment and the Constitution itself and the ratifying convention records as well. So there's virtually no history supporting this made-up Incorporation Doctrine. Again, I urge you to purchase. I have the link on my page, Dave's book, The 14th Amendment and the Incorporation Doctrine booklet. It is a means by which our Republican system of government has been dismantled. We have a result of a one-size-fits-all central government. Rights and powers must emanate from Washington, D.C. As a result of this Incorporation Doctrine, the limited general government has assumed a sovereignty of its own. We are seeing one which has rendered the states mere subsidiaries. Remember, the war for American independence was fought for the right to self-govern, to have social issues decided by the people through their locally elected representative. When we acquiesce to this overreaching of our national government into areas in which powers were never delegated, we have really turned our backs on the principles to issues such as state sovereignty and consent of the governed. By doing so, we've surrendered our revolutionary legacy. If you want to know more about our revolutionary history and otherwise, I want to encourage you to follow Dave Benner. Dave, let's wrap it up really quick. Tell us about your history in a nutshell, and then we're going to announce your participation in our network as well on a continuing basis.
Sure. My website's at www.davebenner.com, and that's kind of a gateway to everything I do, including my podcast. And as you mentioned, History in a Nutshell, which is a series of YouTube videos where I'm breaking down kind of big historical topics into bite-sized chunks that are 4 to 8 minute videos for the most part. You can find that at www.youtube.com/dbenner83. So thank you.
Yes, and then we're going to have your links for those 2 books up on our website as well. And I ran an idea by Dave, and he agreed we're going to do some of these History in a Nutshell shows on our show, which will be interactive. I will either join him or Jeff or any guests that he so decides, or if he wants to fly solo on some, he can as well. So that's an exciting development in the network. And lo and behold, that 30 minutes just absolutely flew by. Jeff Johnson, thank you for producing the show and for all the work you do. Dave Benner, want to thank you for joining me, and follow Dave Benner even on Facebook. His posts are public and he has all of his videos up there. And we will be back with another episode, topic to be determined at a later date. Thank you for joining me. This has been Case in Point. I'm Suzanne Sherman. This is the Cerberus Radio Network, where we defend liberty and freedom from the flames of tyranny. Thank you for listening.